What is the impact of global events on force majeure clauses? Imagine a sudden storm hitting a business just as it is about to deliver a big order, or a worldwide health crisis shutting down factories and ports. These are examples of global events that can shake up contracts in unexpected ways. When such events happen, they often trigger what is called a force majeure clause in a contract. These clauses are meant to protect parties from being held responsible if they cannot fulfill their obligations because of extraordinary circumstances beyond their control. But how do these global events influence what's written in those clauses? Let's explore that. First, because of major events like pandemics, natural disasters, or political conflicts, parties now often include specific references to these kinds of events in their force majeure clauses. For example, after the COVID-19 pandemic, many contracts explicitly mention public health emergencies as triggers. Similarly, trade disputes or sanctions have led to clauses that specify government actions as qualifying events. This helps everyone understand what kinds of disruptions are covered. Next, the importance of clear wording in these clauses has grown. Since global events can be so varied, contracts need to specify exactly which events qualify as force majeure. They also need to outline how quickly the affected party must notify the other and what steps they should take to reduce the impact. Courts tend to interpret these clauses narrowly, so vague language can lead to disputes. Precise drafting helps ensure that, if a global event occurs, the parties can rely on the clause without confusion. Risk sharing between parties is another key aspect. When global disruptions happen, force majeure clauses give a way to pause or change obligations temporarily. This reduces the chance of one side claiming breach of contract if they cannot perform. It helps keep business relationships intact even during tough times. The clauses act as a safety net, allowing flexibility when the world throws a curveball. Different countries and legal systems also influence how force majeure clauses are enforced. Some jurisdictions requiring very specific language, while others are more flexible. This means that in international contracts, parties often include detailed provisions to make sure the clause will hold up in court. Understanding these legal differences is vital to drafting effective clauses that will work across borders. Businesses also use tools to manage their contracts better. They review their force majeure provisions regularly and update them to reflect new risks from global events. This proactive approach helps companies respond quickly when disruptions occur. It also encourages open communication and cooperation with their partners during crises. Lastly, most force majeure clauses requiring the affected party to notify the other promptly and take reasonable steps to lessen the impact. Global events have shown how important it is to follow these procedures. Proper notice and mitigation efforts prevent misunderstandings and misuse of the clause, making sure both sides work together to handle the situation. In essence, global events shape how force majeure clauses are written, interpreted, and applied. They push parties to be clearer, more specific, and more prepared for unforeseen disruptions. For anyone involved in contracts, understanding these impacts is key to managing risks and keeping business running smoothly even when the world around us changes suddenly.